Good afternoon, everyone. Welcome to the third in our Lunch and Learn series, Special Education's Lunch and Learn series, Prior Written Notice and IEP Language with Special Education Advocate and Self-Board Member Virginia Blum. Welcome everyone to this, to this third installment of our series. We're really excited to have everyone today. Just as we kick off, we'd like to thank our corporate partners, WealthSpire Advisors at the platinum level, Winston Preparatory School at the gold level, at the silver level, American School for the Deaf, Chapel Haven Schleifer Center, Eagle Hill School, Fusion Academy, Villa Maria School, and at the bronze level, Shrub Oak International School, the Pinnacle School, and Spire School. Thank you to all of our corporate partners. We could not do this and so many of the other things that we do without your support and partnership. For those of you, I'm sorry, who are not familiar with SELF, I just want to share a little bit about what we do as we start off. Special Education Legal Fund is an organization that was founded 5 years ago to provide resources, knowledge, and support to families in need. We principally do this through two primary grants programs, the Legal Assistance Program for attorneys and the Advocacy Support Program for advocates, both of which I'll talk about a little bit in a minute. We have been providing support for the last 5 years. Since 2018, we've provided over $800,000 in legal and advocacy grants to families in need in the Connecticut and Westchester area. As I mentioned, the Legal Assistance Program is our program for attorneys, and the Advocacy Support Program is for advocates. Both programs are currently accepting applications. The Legal Assistance Program provides families with up to $6,000 in grant support. Advocacy Support Program is $1,000 in advocacy support. And to begin the process, please visit our website. This actually is not exactly true. The next deadline for applications is actually tomorrow, November 15th, but we do process applications on a monthly basis. The applications have to be received by the 15th of the month, and the required interview must be completed by the 22nd. So just keep those deadlines in mind as you move forward if you're interested. You can scan this and go through the pre-screening process, which happens on our website. After you complete the pre-screen, you'll have an application. The interview, as I said, must be completed by the 22nd, and we notify all families by the end of the month in which they apply, which is generally the 30th or the 31st of that month. Please click on this QR code, or scan this QR code, I should say, to start the process. Our next Lunch and Learn, we're going to take a little break for the holidays. Our next Lunch and Learn is January 23rd, which will cover present level of performance and goals with Virginia. Please scan the QR code to access this in our next two Lunch and Learn series, or any of our webinar programs. You can access through this link and through the Eventbrite link that you used to sign up for this today. Tomorrow night, we have our dyslexia webinar, which is going to be great, moderated by Lara Damashek, who is a CSE rep at Windward School and a special education advocate. This webinar will feature, really how schools support dyslexia in their programs, and will feature representatives from Winston Prep, Villa Maria, Pinnacle, the Windward School, and Eagle Hill School. Again, you can sign up for this webinar by scanning the QR code. Finally, we, after all of the advertisements and whatnot, this is we're really, really excited that Virginia's doing this series with us. She has great experience as a special education advocate. She is a board member of SELF. She's completed the SEAT 2 program at COPA, and more importantly, she's a mom. She lives this world. She walks the walk, and we're really excited to have her with this presentation today. Wouldn't be a webinar without a disclaimer. This webinar panel is presented for informational purposes only. This webinar is intended as a resource for families who are navigating the special education system in Connecticut or New York and is not intended to provide legal support, advice, or assistance to any particular individual, nor is it intended to replace the advice and counsel of a qualified special education attorney. Families in need of legal advice, support, or assistance should contact a special education attorney licensed to practice in Connecticut, New York, or the state of their residence to discuss the specific needs of their individual student. This webinar should not be construed as an endorsement by Special Education Legal Fund or any of its representatives of any of the participating attorneys, advocates, or professionals in the panel. Thank you so much. And I'm going to turn it over to you, Virginia.
Thanks, Christine. I'm really excited today to talk to you guys about something that I think is not a topic that a lot of parents really know about. So I'm going to talk about the IEP language because we use a lot of three-letter acronyms, and I think, it's important to know what they stand for. And then we're going to really get into what does prior written notice mean. So, just generally, IEP language, what does it mean? So an IEP, that stands for an individualized education plan. And it is a document that is developed for identified special needs children that outlines sort of their individual program and what supports and services they will receive. This is different than a 504 plan. A 504 plan is developed to remove any barriers to a child with a disability in accessing his or her education. It's under a separate part of the law. It's part of the Americans with Disability Act. IEP was developed and is under IDEA. So they are two separate laws that govern them, and they are different documents. A 504 should encompass both leveling the playing field, so good accommodations. It can also have related services attached to it. PPT stands for Planning and Placement Team. This is the team of both school professionals and parents and students that come together to discuss and develop the individual program for the student. So you as a parent are part of the team. They can't meet without you. You're valuable. You're just as important as anybody around that table, and your opinions and your concerns need to be addressed. And as your child gets older, it's often that we invite the student to also participate in these meetings. PLOP stands for present level of performance. It's the baseline. It's the starting point for your child's current IEP. It's very important because this tells you kind of where they are right now in this moment in time during this meeting. It's something that I feel like teams don't talk about, and stay tuned because my next presentation in January will be talking about that important part of the IEP. LRE is the least restrictive environment. A child must be educated with non-disabled peers to the maximum extent possible. So, if your child is, in a self-contained classroom for the whole day, we might want to think about, is that student's least restrictive environment? So that should be something that school teams are thinking about as we talk about services and where to receive services. An IEE is an independent educational evaluations. Parents have the right to request an IEE if they disagree with the evaluation done by the school team. We've touched on that slightly. It is, again, a topic we could spend an entire webinar on. And we may, that may be something that we think about for next year. And then a BIP, a behavior intervention plan. This is a proactive plan to address problem behaviors that are hindering your child's ability to access his or her education. Typically, you would have a functional behavior analysis done to
An FBA.
another.
Just to throw that out there.
Yep, another three-letter word. To help support what the function of the behavior is and helped us develop how a behavior plan should be tracking and working on both not only the maladaptive behaviors or the behaviors that are problems, but also the pro-social and the replacement behaviors in which you're trying to get your child to do. So those are kind of, I think, the most three-letter words that we need to get to today. Next slide. So prior written notice, and a lot, again, that's another three-letter word, PWN. What is it? And also don't ignore it. So prior written notice is your legal right guaranteed to a parent with a child with an IEP. So one thing that I want to stress now in talking about prior written notice is this is a tool and something that's under IDEA. So that's under the IEP realm and bucket. It is not a part of the 504 law. So it doesn't really apply to that document. So again, it only applies to students suspected of needing or receiving special education, not a 504 plan. So anytime you have a PPT meeting, you have this ability to document things on prior written notice. The purpose is to inform the parent in writing of the school district's proposed changes to the child's IEP. And that can be at PPT 1, where we're talking about whether or not we want to put evaluations in place. The district can either propose to do that or not propose to do that, and you have your right to agree or disagree with that recommendation. So again, you would document things on prior written notice. The district provides written notice when they deny you a request. So if you make a request at a meeting and they say, we don't think we need that, that's your legal right. You need to make sure it's documented on prior written notice. And it's information for the parents to actively participating in making decisions about the child's education program and services. So we're going to kind of dig down deep. So I'm going to go to the next slide. Why is prior written notice important? And again, I think this is an area that we always say, read your document, but I think at least in the state of Connecticut, prior written notice is now a separate document, but don't ignore it. This is probably the most important thing you can look at besides your IEP, but you want to make sure that it captures every request that you've made or the school team has made. It gives you a lot of information to help you as parents understand why there is a disagreement with the school, why your child isn't receiving more speech, why your child isn't, qualifying for a specific service. It, explains what information the school team considered before making the decision. So that's really important. Like if you ask for, I am requesting, more service, and they say no, in that document on prior written notice, it has to say why what information did they consider before they said no. It can be used by parents as evidence if you decide that you're completely at odds with the school district and you're going to go to a hearing to resolve your dispute. So again, that's your legal right. I made this request. The school district denied it, and then my child did not make progress. And it also discourages bad decisions by requiring that you write it down. So sometimes if you're in a meeting and you say, I am requesting a one-to-one aid, para support, and the district, your child has, it's dangerous, there's a safety issue, it's a concern, you don't think your child is safe. The district, if they say, oh, we think we can do it without that, and if you don't feel that way and you say, please put that down on prior written notice, I have been in meetings where they backpedaled and said, oh, we don't want to do that. We'll give you the aid. So, or we'll give you, maybe it's not a 1-to-1, but we'll give you a 2-to-1. So, again, it helps parents have a little bit of an edge in terms of, I'm going to require you to document why you're not going to give this to my child. And that sometimes gives the school district pause. Next slide. So what is included in prior written notice? And this is, it's a really important document, and each section is sort of broken down. But I think that understanding how to read the document helps you know where to look. So the first part of prior written notice is a description of the action proposed or refused by the school team. So what did you request? What was it? Was it an aid? Was it more speech services? Was it a change of placement? What was the request? And what did the school district decide to do with that? Did they refuse it, or did they give it to you? It's an explanation of why the school proposed or refused the action. So what did they consider when they made the basis of that decision? Was it, their evaluation? Was it the child's current performance? What was it about the decision that they considered? A description of each evaluation procedure, assessment, or report that was used to make the decision. So, where was the information that led them to, this is a good decision? So if you're thinking about, my child has dyslexia, I need OG Orton Gillingham instruction, that's the gold standard. So they would have to then tell that, use some evaluation, assessment, some report that's kind of debunking that. A statement that the parent of a child with a disability has protections under the procedural safeguards and how the parents can get a copy. So
That's
again,
that piece of paper you always ignore when that to give you at the beginning of the meeting.
yes, but you need to be informed that you have the right, if you don't agree with this decision, and what you can do with it. So they have to have that statement of the fact that you have access to procedural safeguards, and if you want to get a copy, where you go to get a copy. And they usually, if you're in person, a lot of times they leave it on the table. It's a thick document, as Christine talked about, but that has to be on prior written notice. Sources for parents to help understanding these provisions and safeguards. So, you can ask, who can you turn to if you are confused? A description of any other options that were considered and the reasons that they were rejected. So we considered, a scaffolded support. What other else did they think they could consider with that request, and why that those were also rejected? And a description of the other factors important to the school's proposal or refusal. So again, if you think about that, that's a lot of information on, it's two pieces, it's a front and back of one piece of paper. So, and every time you make a request. So if you request in a meeting, if I request an aid, that's one request that should get prior written notice. If I request more speech services, that's another prior written notice. So I would say if the team agrees to it, they usually use a blanket statement like, the team is in agreement to change FAPE to implement these 5 things. It's what you as a parent, if the team is not in agreement, that's where I like to see it very separate. These were the 5 things that I requested, and these were your answers, because the answers will change. If I'm asking for para support, that is the basis of why I'm not getting that should be different than me asking for, a scope and sequence structured literacy program, right? So we would want to see different information on this form.
What
Next
happens if what happens? There's a couple questions in the chat, and I thought I'd throw this one out there.
Okay.
What if the parent and school don't agree, but the school fails to provide prior written notice?
So I'm going to put that in the thing later, but
Okay.
But this is what I would say is very simple. If they don't give it to you, you need to immediately, when you review your prior written notice, which, different districts are sending it at different times. Sometimes it comes before the IEP comes in, because again, in Connecticut, it's 2 separate documents. If you, write down that you made the request and you don't see it on prior written notice, you immediately need to email the administrator that sent you prior written notice and say, you did not include these 5 things. Please update my prior written notice, my due process rights for these 5 requests that I made. So you absolutely need to follow up, and that email is documentation that I'm following up. Next slide. So when do you receive prior written notice? Changes need to be discussed at the PPT meeting, or they can be agreed to via amendment. typically, if you don't know to ask for an amendment, it's typically done at a meeting. Sometimes I'll see like at the end of the school year, if all of a sudden the team says, oh, wait a minute, this child really needs extended school year, we want to offer them summer school. Sometimes they'll do an amendment for that. You can ask for an amendment, but any changes that you discussed need to be on there. Prior written notice is sent to the family no later than 5 days after the meeting. Again, so if the meeting is today, 5 days later, you should have your due process prior written notice. The reason is because you have 10 days once you get the prior written notice and the IEP before the district's going to implement any of these changes. So again, we talk about your due process rights, and this is the timeline. You get the notice 5 days, and then you have 10 days once it's received to say, wait a minute, time out. I want to exercise my due process rights.
So just to clarify that timeline, you have the PPT meeting on day 1. On day 5, you should have the prior written notice. And the day that you receive the prior written notice, the 10-day period starts for you to review the IEP and the prior written notice before changes can be implemented. Is that correct?
Yes.
Okay.
Now I will say this, it's a total of 15 days. So if the district is slow in getting you this document and it is past 5 days, you don't get an additional 10 days. Like it's 15
Gotcha.
days from the
Right.
meeting. So, but I will say, in general, I'm seeing that prior written notice is almost coming in a day or two after I do a meeting, and the IEP may lag. And again, read the document. If it comes and it doesn't have everything that you talked about, that's a problem and you need to document that. If the parents do not respond or challenge the prior written notice, the changes are implemented in the IEP and the child's program 15 days from the date of the PPT.
And that's the total 15 days that you were talking about.
And if the parent doesn't receive prior written notice, request the document in writing. So if you don't get it, ask for it. And if you get it and it's incomplete, ask for it, tell them that they need to give you 5 more prior written notices. I mean, it just sort of depends, but this is a really important part of your child's IEP. It's protecting that you made these requests. So, for instance, if I'm in a meeting and I think this child needs, I'm going to use reading, a scope and sequence 5 days a week reading intervention for an hour a day, and the district denies that, and I put that on prior written notice, and we come back 6 months from now and the child hasn't made any progress, I can go back and say, well, I told you, because on this date I said I didn't agree with this plan and I wanted more. And it's important because that becomes, then you can prove that you made that request. So it's a really important tool. Next slide. So this is just a slide that shows the prior written form in Connecticut. So again, it is clearly marked prior written notice at the top. It'll tell you the purpose of what prior written notice is. The section that says actions proposed or refused. So these are check boxes. So the district is proposing to initiate means they accepted it, right? And this one just happens to be an evaluation. But if the district is refusing, that's the box below it, right? So they're refusing that request. And then what is it that, that you made the request? And then it's the description. What did you ask for? And why is that action, agreed to or not agreed to? And then again, you can see the reasons that this is refused. The description of the procedure is the next bucket. So all of those things that we just talked about are on this form, and then and then it says, please note, and there's your due process procedural safeguard information.
Can you touch on the other options the PPT considered and rejected? There's a question in the from the audience, what if no other options were considered? And
so a lot of times, what I will tell you is, a lot of times when you're in that meeting, they don't consider other options. And then it'll be really interesting to see what they write down in this form. So what I would say to you is, instead of having a screaming match or getting really upset, you say, I'm going to be very clear. I am making this a request. They answer, they might say yes or no. And if they say no, you just say, please document that on prior written notice. And then it's interesting to see what reasons the school team puts down. So a lot of times it says the educational performance, I forget that it's educational performance supports or substantiates the refusal. And that's an interesting one because you may have a lot of information, decreasing NWE, scores or decreasing Linkit or whatever you're using that are supporting the fact that that actually isn't true. And again, that's an interesting point for the school district to take because they have now put in writing something that is basically not factual. So, again, and if you disagree with the way that they're characterizing that, an email to say, I'm not in agreement that you considered these other options that are on this form.
This is all about kind of documenting the steps in which you take to make changes in the plan and the program. There's a couple of questions that, the participants are asking with regard to, what if you consider the evaluation criteria as insufficient? Or what if the team is only considering the child's grades? What are your, sort of options at that point? I mean,
well,
I guess.
A lot of times, like, first of all, grades are one data point. So, again, if I'm in a meeting and we're talking about the fact that the kid has solid A's, that's one data point. Again, look at the evaluation. If we have solid A's, but the evaluation is saying that there's a decoding weakness, right? We know there's a struggle there.
Right.
Or
if the child has behavioral challenges and is like, even though they have grades, the good grades, they still have behavioral challenges and are showing signs of anxiety. Those are other data points.
Right. Again,
good grades are not proof that everything is working.
And if, good grade, right. And if you can have a good grade, but if you aren't coming to school regularly, that's a problem too. So it's hard to, every kid is so specific that it's hard to, but if they keep harping on one thing, you just have to come with, but what about over here? And you also, again, you have your IEE request. So if they're marching down, we have good grades and the evaluation's not comprehensive or not helping you, you can ask for an IEE. And again, that should be documented on prior written notice. I'm making a request for, I don't agree with your evaluation. I don't agree with this. I'm making a request for a psychoeducational IEE. Now, again, that's complicated because they have 10 days outside of the meeting, but
but that's a totally different topic. What about, I mean, I have a couple of, participants who are asking about, if you respond and, indicating, X, Y, or Z, the evaluation criteria is not sufficient, other options, whatever and the school doesn't amend, what happens if the school doesn't amend the prior written notice?
Well, they might not. I mean, if you point out that, like, so let's, in the example that you gave, Christine, that you're saying, school performance doesn't support that refusal, right? I mean, again, you're disagreeing. So there is a disagreement there. The district is saying it does. You're saying it doesn't. And then you have to rely on your procedural safeguards. So it depends on, what the request is and how impactful that is. Can you give it 3 months to see if it's going to turn around given the district's proposal, if they didn't change anything, or can you not do that because your child's not safe? So I can't, that's where your
blanket stay.
and you can seek counsel, you can talk to an advocate, you can talk to an attorney. That is sort of what your due process rights are. And you can file a state complaint. Like, that's a whole nother webinar.
And the school district, I mean, so that I have another question, and then actually I have two more questions, and then I'll, keep going. I just thought this was a good time to address these.
Sure.
Is the district required to explain, is the team required to explain procedural safeguards to you?
Yeah, 100%. And they need to explain this document to you. So if you get this document and you don't understand it,
you have to ask, but you have to ask. Yep.
Yes. And you have to put it in writing. So if you ask the question over the phone, or you have a sit down with the vice principal, then you need to follow up with an email that says, thank you so much for taking the time. I'm still not in, I still don't, I'm not
Still don't
in
understand.
this section,
Yeah.
or I still don't understand. Did you have one more question, Christine?
And then there was one, well, you can, were you continuing with that, or, I do have one more question.
Okay, go ahead.
And it is, what can you wait 3 months if you only have 15 days to review the prior written notice in the IEP? I don't know what that means, actually.
Oh, well, what I meant with wait 3 months is you've documented the disagreement
Mhm.
and it sort of depends on what the disagreement is.
Right.
So, for instance, a change of placement. If the district is recommending that your child go to a different school and you want your child to remain in the current school and, in the public school, you can't, you have to actually act. That's a change of placement. Like that requires, either a stay put. That's very complicated.
Right.
If it's so, there are some actions that no, you can't wait
Right.
past the 15
Right.
days, and you need to understand your due process rights
Right.
at that point. And you
Right.
need,
Like, if your child's not safe, obviously we're not
right.
expecting that, you wait 3
So,
months.
right. But
If you're
if it's a reading, like, or a
right.
related service, like let's say you wanted direct occupational therapy and the district said, we want to do a consult model and then we'll come back in 3 months and
Right.
see how the consult's doing.
Right.
You can document on prior written notice that you're not in agreement with the consult and I am requesting direct occupational therapy services
Mhm.
once a week for 30 minutes, right? And that would be documented on prior written notice, and they would talk about why they didn't do it. And then, I think you can wait 3 months to see if a consult model is
In
going to
that
work.
particular situation.
So
Yes.
again, it depends on what the request is and what the district's requesting and what you want, and where your child is in their learning.
Mhm.
Next slide.
Perfect.
So this is sort of when prior written notice is required. So anytime they want to conduct an evaluation or a reevaluation. So if the team is recommending, an evaluation, a
Mhm.
survey, then they have to put that on prior written notice.
Mhm.
And again, you have to sign consent for an evaluation.
Mhm.
The school says no to a parent request. So again, anytime you ask for something
And they say no.
and they say no, that is supposed to be on prior written notice. And this is important because a lot of times I pick up an IEP and the parent is saying, oh, the meeting was horrible.
I asked for this, I asked for this, I asked for
And
this.
I look at the IEP and it literally says all members of the team were in
We're in
agreement.
agreement, yes. I
And
say that all
like,
the time. Yep.
right? And you're part of the team. You as a parent are part of the
Right.
team. If you weren't in agreement, then you need to say, I'm not in agreement.
Right.
I'm
And you have to
requesting.
review the document once you
Yes,
receive it and say, you can't just assume that the document coming back to you is going to be an exact reflection of what happened. If
right.
it doesn't say that you disagreed, then it has to say that you disagreed. And that's very important to do. It's a check on, the system, pretty
Yes.
much.
Eligibility determination for services, or if you're not eligible for services. So, again, that needs to be on there. Changing the disability category. So I know last time we talked about all the different categories. If we have a kid that's qualified under one category and we decide to change it to another category, really that should be on there. We've talked about placement decisions, but anytime we're going to recommend a different school, or anytime that you as the parent want to ask for outplacement. So if you're in a meeting and you say, I want my child to go to an out of district placement and the district says no, that needs to go on prior written notice. And the change of provision of FAPE. So if you decrease or increase services, if you change goals and objectives, anything that you change in that document, usually that is more a broad one where it'll say, we've all agreed to change the provision of FAPE to include, we updated the present levels, we changed goals, we, added and subtracted services. So that's usually a broader bucket. But again, if you think that the school district did not add enough services, or didn't add, if they said push in and you wanted pull out,
Mhm.
that all should be documented, that you're not in agreement that what that recommendation was is what you think your child needs. Next slide. When do you not get a prior written notice? Like, right? So
Mhm.
when is this not something that you're going to get? Any kind of general screening. So if they do it for every child, so like at the beginning of the year in elementary school, if every child gets the dibbles,
Mhm.
which is a reading screener,
You're
uh,
not gonna get a
you're
prior
not,
notice
or
for
the
the
link
dibbles.
it, which,
Yeah.
or anything. So, state standardized testing, like, again, that's done by every student, and every student's getting that now. So that wouldn't go on a due process prior written notice. Um, Information on goals. Again, it's a request. It's not what we're putting on the document.
Mhm.
Class schedule. So if they call you and say, I'm going to switch Mary Jo's science period from period 1 to period 7,
Mhm.
that's not, again, we don't talk about a child's schedule. We talk
Mhm.
about what services they need.
Right.
But how they're going to rearrange the schedule isn't impacted on prior written notice. And
Okay.
if you want a classroom, teacher assignment, that's really outside of this IEP process.
Mhm.
So if you're in there saying, I don't like my teacher and I want a different teacher, that's not a prior written notice issue. Like, you can definitely, though, what is if you think that your child requires an expertise. So, if I think my child needs, a BCBA,
Mhm.
board certified behavior analyst, and I'm requesting that, and the district says no, that is. So I'm
Mhm.
not requesting a certain person or a class
Mhm.
assignment, but I am requesting a certain level. So again, if you think your child who has dyslexia needs, a certified level 1 Wilson teacher, and that's your request, that goes on there.
Right.
But not, I want, this awesome teacher, like, and
Right. Right.
they're not
Right.
gonna, that's not on prior written notice.
To that point, in terms of the class schedule, I know that, for certain, learning challenges, changes to class schedule can be problematic, if you have a profile where the child has autism or whatever. And also, obviously there are certain profiles where, maybe the child's learning profile means that they learn much more effectively at the beginning of the day. Is that something that can be, incorporated into, an IEP prior written notice type of requirement? Maybe, maybe not.
I mean, again, schedule doesn't really impact it. You can certainly, I'm not sure that's a direct request.
Okay.
Um, I think you can, put in the minutes in the recommendation that they can try.
Mhm.
I think, and again, I think it depends on what it is. I would say more expertise. So if you
Yeah,
wanted a reading teacher, you would be putting on prior written notice that you
right.
need a Morton Gillingham person, or this or that, or a
Okay.
parent can't deliver the service, right? A para, like, that's
Mhm.
not, so I want the teacher delivering the service, but I'm not, schedule is really outside of.
Okay.
Important considerations for prior written notice. All letters or notice the schools must be sent must be written in the parent's native language.
Mhm.
Gotta understand this. This is your due process right, so you can request it be in, not in English. Um, if this is not available, the school must take steps to verbally translate the notice to parents in the native language. If you do not understand the notice, keep asking questions until you fully understand what the school is asking or proposing or refusing. Like, it's okay to ask them to explain it to you. It's important that you understand what's in this document.
I think that that's an important point just before you go on to the
Yep.
next, is the keep asking questions a point of it. The school, I think that there's sometimes you know, an assumption from, that like the school's not going to affirmatively explain things to you. You know, they're only going to explain things to you if you ask them to explain things to you. If you don't ask questions, they're going to hand you the piece of paper and keep moving on.
Totally.
And so when we talk about like, is the school required to explain, you know, certain things to you? The answer is yes, but like you have to ask.
Yeah, you do, you know, and you have to follow up. And again, if they verbally explain it, and it's not the same as in the written document, then it's what's in the written document that counts. So if they say, "Oh, don't worry about that. We all agree with you." Like, no, you have to, your document has to reflect what they're telling you. And so again, if it's verbal, it didn't matter. And so what's in writing is what we're going to go back to. Next slide. This is what I was saying. What if I do not see my request on prior written notice? Request an amendment to prior written notice immediately. So in writing, you get the email that, or the notice from CT said that says you have a document waiting. You go look, it's prior written notice. It doesn't have your request. It says everybody, you know,
everybody's in agreement. Everybody's fine.
Yeah,
we're all
not
fine.
Right. Then no, that's not what happened.
We're not fine.
We're not fine.
We're not fine.
It needs to be on prior written notice. So you send an email. Thanks so much. I noticed that I only got one notice. I am requesting that the prior written notice be amended, and I want all these requests put on there. You know, and just bullet point it. And again, you know, I am at a place where generally all of the PPT meetings are recorded. Which you have the right, as long as you tell them that you're recording, to record.
Always a very wise thing to do.
And so if you've recorded, the other thing to do in that sense is to say, you know, I'm requesting this, and if you'd like to review the recording, please feel free, because you can clearly say that I made the request. So if I'm in that PPT, I am requesting, please document that action on prior written notice. And I say that throughout the meeting, not to be intimidating, but because I want the record to be accurate, and I want them to understand that I made that request and I'm expecting to receive a prior written notice documenting the request and the answer. And again, it needs to be coming out of your mouth when you make the request. If they say no or they say yes, whatever they say, great, put it on prior written notice. Just get used to using the vernacular.
And what if they refuse to document the disagreement?
Well, that's not legal. And again, you know, if that's another reason to record your meetings. Right. But
and then your email about this is also evidence that, you know, you've made a request, they've denied it. You know, all of these things are about building a case, really. And I know that we're talking a lot about, you know, it's like, well, they didn't do this and they didn't do that, and they didn't document this and they didn't document that. Like, that's all bad, but like, we need to remember, like, you know, the forest for the trees. You know, the end run of this is, if they're not documenting it and you've written them and there's documentation, you've recorded it, then you have proof that they didn't do this, and this is a violation of your rights, which is evidence for you at the end of the day.
Right. You know, or, you know, the other, I mean, I will tell you this, I've never been in a meeting where I have said, please document this request on prior written notice, and the school district says, we're not going to do that. Okay. I've only had one meeting where that's ever happened, where I ask a question and they refuse to put it on there. And what I said in that case was, you know, I want to be really clear, and I was recording. I want to be really clear that the administrator of this meeting is refusing to answer a question. That is not legal. Like, any, you know, that PPT team is designed to have somebody that can answer any and all questions from the parent, and cannot make unilateral decisions. So they can make recommendations, and if you're not in agreement, again, you have to state that, right? And sometimes you are in agreement. So like, sometimes it doesn't have to be like that. Sometimes they say, oh, sure, I agree with you. So, but yeah, just, you know, if that happens, I would say run to an attorney.
Mhm.
Next slide. Other facts concerning prior written notice. So I think I've said this before, but it is a separate document. It's no longer in Connecticut part of the IEP.
Mhm.
So again, I have lots of people that will send me the IEP after the meeting, please review this. And I always say, and where's the prior written
Right.
notice? But you need to make sure you're looking at that IEP and that prior written notice.
Mhm.
And more than one
To
prior
make sure they all accurately reflect what happened.
everything is, more than one prior written notice may be required if the district proposes or refuses multiple actions. Each
Mhm.
request needs to be on the document.
Mhm.
So I think it's really important to have one request per document. But if they sometimes I've seen districts that have said, we're going to do this, and then at the bottom they say the 5 other things that I've said. As
Mhm.
long as it's on prior written notice, my
Mhm.
understanding is it's good. But you can write back, I'm confused by
Mhm.
how you presented this. It's my understanding that you need to be putting this on separate documents, and get them to document that they aren't going to do that. Like, writing down I'm confused as a parent is a great thing. Like, get the district to explain why they're not doing it appropriately. And it must be provided at least 10 days before the action is taken. So again, this is the legal part of it.
Mhm.
So if if they are going to take speech services away, they can't do that. You have those 15 days to go research and figure out how you're going to respond to that
Mhm.
action and what makes sense in each individual case. That may be the last slide. I can't remember, Christine.
Yes, it
Yeah.
is.
So I don't know if you have any other questions. I know that was a very, again, prior written notice is a legal tool. And it's a tool that I don't think parents know about.
No. And I think it's important to understand that in the context of what prior written notice is, it is a means to which a parent can have a sort of documentation of the decisions that are made. And this is not to say that, it's a tool to make the district agree with you every time. But what it is, in the case that there's a disagreement, you want that on paper and written down. And that is all because, we're not always about building a legal case, but you kind of are. So these are the tools that we have, and it's important that parents know how to use these tools because, as Virginia said, very often the use of the tool, like saying, "Are you going to document the reasons why you're denying this?" is a reason that maybe they won't deny it, or maybe they'll look again at it, or maybe they'll choose to review it in a different way with different criteria. So that's a really important thing, is that, prior written notice is forcing the district to explain the decisions, why and why not they're doing something.
And I'll
And
give you
that's for you.
a really good example of something that is a strategy, and again, I've been talking about services, and I never go into a meeting and just talk about services, because that's the 4th thing I talk about. I talk about present levels,
Right.
and I talk about
Right.
goals, and I talk about objectives, and then I'm getting to the service piece. But if it, as a way to compromise, right? But to still have your say, if you think your child needs daily, like say your child is a nonverbal student, and you feel strongly that the child requires daily speech,
Mhm.
for 30 minutes in a one-to-one setting,
Right.
you can make that request. I am requesting every day 30 minutes one-to-one speech for my nonverbal child.
Mhm.
They may say no to that, and you say document, and then you can say, well, what are you
What
gonna
do
like?
you propose? Yeah.
See, right now
Yeah.
he has only 3 days a week,
Right. Right.
right?
What's your
In a
suggestion?
small group, right? Or something.
Exactly. Yeah.
What can
What's your
you,
suggestion?
what's your suggestion?
Mhm.
And sometimes I can move the needle, but I still have documented that I thought that it really should be every day.
Right.
So even though I'm getting to a compromise, I still have that bright line of that I really
Right.
wanted it
That I
to go
wanted this, and these
and
were
you
the
didn't
reasons
think
that that was
so.
denied. Right.
And
Exactly.
but we still moved it up. We maybe
Mhm.
from 3 to 4, right?
Right.
But I
And
still
even,
want
and if you go back, and we can go back to the, sort of 3 months, like, later, or whatever time period you're talking about, and you still haven't had progress with the compromise position, then you can say, well, look, 3 months ago, I asked for this, you said no, you gave me a little bit more, and that still wasn't good enough.
Mhm.
So all of this is sort of about documenting the different pieces of, why the team does or does not choose to do something,
Yeah, and the other point, the
and
other thing
making them
about
accountable.
yeah, the other thing about that, like, again, when we're talking about services, really asking the question, how are you delivering that? So if you're saying that, I'm going to get reading instruction, right? And yay, it's every day and it's 45 minutes, but it's going to be in a small group.
Mhm.
Ask them, what's the group size?
Right,
Because if you
right,
find out that that group size is, at 8, 10
right.
kids, I would argue that that's not a
That's not small. Yeah,
right? So
exactly.
like,
Right.
but again, then you can then put, I would like my group size to be limited to no more than 3
2 to
similar,
5 or whatever,
whatever it is. And it
whatever it is.
depends on, and it also like, there's difference in delivering reading instruction versus social skills. Like maybe you need 5 kids in a social skills group, and maybe that is a better group
Right,
because your kid is
right,
different, or
right.
different peers. So, again, but just keep asking those questions.
Mhm,
And if you aren't in agreement, you do need to say, time out. I don't think that's right.
mhm.
I think it needs to be more. I'm asking for this, and I'm asking you to put it on prior written notice. And I
Mhm.
think you do need to, parents, follow through with that last comment. I want it on prior written notice. Please put
Right.
it on. I'm expecting to receive, when I receive this document back, I'm expecting to receive that request on prior written notice. And I think too, as a parent, if you start to use that and you'll feel empowered. You'll
Mhm.
feel like, they have to listen to me,
Right.
have to put it in
They have
documentation.
to explain why they're choosing to do something or not do something.
Yeah,
What were the reasons behind it? And that is, in and of itself, it is empowering. It is not, it's not necessarily that, the team is always going to be in agreement about what the next steps are. They're not always going to agree with you, but if they don't agree with you, then this is the way that, we need to we need to document the situation. Virginia, this has been really, really tremendous. I have to say, I learned so much about prior written notice, topic that, sadly, I'm very, very, have very meager knowledge in. And I really, really appreciate you taking the time. This is a great series. And everyone, we look forward to joining us for our next Lunch and Learn series with Virginia in January. And if you're interested in how schools support dyslexia and students with dyslexia, please join us tomorrow night at 7 o'clock, November 15th, for our school panel about how different schools that specialize in special education support students with dyslexic needs. Thanks so much and have a
thanks
great
guys.
afternoon.
Bye now.
Bye.